Hey, this is Alex Yoder with Pro Tip Tuesday, my favorite day of the week. And I'm here with attorney Ken Davidson. And the intent here today was to talk about a number of things, but primarily circling around the CDC order and the eviction moratorium and what that looks like in the El Paso County market within our state and within our county. So Ken, I'm going to start out here. One of the previous challenges that we were kind of faced against once the CDC order was released was effectively you were hoping that a tenant either didn't read or didn't show up in court. Because when they're showing up in court, the judge is basically saying, well, I can either evict you today, I can award a judgment for possession, or you can sign this piece of paper. Now, I would say that for most of us, or for many of us, when the statements in the declaration are 100% correct, we have a little bit more of a heart for that. But we're seeing a lot of fraudulent activity with people submitting those when it doesn't actually apply. And of course, landlords many of whom only have one house, trying to evict somebody and not get foreclosed on their own house while they struggle to pay their mortgage. In my experience, where we have situations where the tenant or where the owner has the finances to carry this, I'm seeing a lot of flexibility from landlords in doing payment arrangements, saying, hey, this month or two that you couldn't pay, let's wrap that into the remainder of your lease. So lots of flexibility from my perspective that landlords are giving to tenants, but sometimes we simply have no choice but to evict. And so can you speak on sort of what you're seeing at the courts? And then we had talked a little bit earlier here about some new state regulations pertaining to the CDC declaration.
Okay. Right now, at least in El Paso County, and my best guess is it differs in every county because the judges don't have any direction on what they're supposed to do or not do. And so right now what's happening is the court is advising the tenants if they show up for an eviction hearing that the CDC order is out there, and they actually have copies of the declaration ready right there. Our clerk's office has copies of the declaration. So if I, as a tenant, walk into the clerk's office, they'll just hand me one. And they basically, the tenant just signs it and files it, and that's all they have to do. Our court, if there's no declaration to argue about because the tenant hasn't done anything or doesn't show up or whatever it is, our court will grant an order of possession. Our court will grant a writ of restitution that you can take to the sheriff. And the problem is our magistrate right now is looking at it used to be that writs were issued by the clerk's office. We'd file them, we'd get them back 15 minutes later, and we could take them to the sheriff. Now they're all going to the magistrate, every writ. And the magistrate looks at them, and if in fact it's for a money demand, so if there's on your notice that we're evicting on, if you said anything about money, then she marks the writ and attaches to the writ an order to the sheriff that says to the sheriff, if you get a declaration from the tenant, you are to cancel this writ. Now, she spends a lot more words saying that, but that's what it is. And what the sheriff does is the sheriff literally goes to the door when you show up to serve the writ. And so this is when you're there, when all your moving people are there, you're all fired up and ready to go.
Mhm.
And the sheriff obviously talks to the tenant if they're there. And the sheriff, I believe, has been instructed by their office, whoever, their training is coming from, that says if the tenant says anything about the CDC, Trump, eviction moratorium, anything that would indicate that maybe they're not supposed to be evicted, the sheriff then carries a stack of the declarations, hands it to the tenant, and tells the tenant, read it and let me know. I even have one case where my client said the sheriff gave it to him and said, you've got to file this by 4:00 today. And they canceled the writ and left. And then, of course, the tenant took it to the court and filed it. So if the tenant files it, then they're going to cancel the writ and refuse to throw them out. And unfortunately, even the order that the judge gives them tracks the CDC language that says every adult tenant in the property is supposed to sign a declaration. But I'm not sure, again, just because I don't know how the sheriff is interpreting it, but I think if they get a declaration, they're probably going to cancel your writ. The court actually tells us, we're going to give you the writ, but you may not be able to do anything until January to get it served. So that's the problem right now.
So let's talk about that, just to kind of backtrack for folks who aren't doing evictions every day, so they're not really familiar with the process. So you are, in the event of a non-payment, you are posting a 30-day notice. And upon the expiration of that 30-day period, we can then proceed to work with somebody like you, or I guess if we're really brave, try to do it ourselves and screw it up, pursue that eviction with the courts. And
yes.
And in those cases, again, non-payment, we posted our 30 days. As a landlord who is struggling to pay their mortgage, we're hoping that they didn't read the CDC order before any of this is happening. When we show up to court, we're hoping they don't show up, because then at that point you may get a default judgment. But even if you get a default judgment, as you just said, the sheriff is required to effectively educate the tenant on the law. So the judge is getting involved with giving the tenants effectively free legal advice. They've kind of roped the sheriff department into giving the tenants free legal advice on this order. And so there's what I see as a series of landmines and possibly a lot of wasted time and a lot of wasted additional money in trying to get them removed from the property. Now, let's say that they submit the order. Maybe they're in front of the judge and they do show up to court and the judge says, I'll evict you or you sign this. And they, being any reasonable, rational person, would rather sign a piece of paper than get kicked out of their house. They submit that at that time. What kind of control or implications are there for landlords if we feel that one of those statements is fraudulent? They're not actually complying with the strict requirements outlined in that declaration.
Our court has advised that they will allow us to set a hearing on the validity of the declaration. And basically, we just have to request that, and then they'll schedule a hearing. I have not had one yet on how the judge is going to deal with that, but I can tell you that from we've had several different hearings surrounding the CDC declaration, just not any on the declarations themselves. And the judge, I can tell you, is it's going to be the landlord's burden to prove that statements are not correct or inaccurate in in the declaration. The two principal ones are the tenant says, I'm using my best effort and to pay the rent, and I've attempted to find another place to live. To me, that second one is going to be almost impossible to challenge, because all the tenant has to say is, I looked in the paper, I looked at Alex's website, and I can't find a house.
Yeah.
The one that is more disconcerting is I'm using my best efforts to pay the rent, because I can see there where the first question that comes to mind for me is, well, what have you done to try and get rental assistance? Because we have this state program out there that they can apply for. There's churches and charities and all kinds of places that have for years, I mean, not just because of the virus, have provided rental assistance,
Mm-hmm.
but proving that they have used their best efforts is difficult. And the other one is what's going on with their income, because I've had many landlords that say, well, wait a minute, they're working full time. They never lost their job because of the virus. They work in an essential position. And so there are arguments out there to challenge that declaration. How sympathetic the court is going to be to the landlord is still wildly up in the air. And right now, everything coming down from the government is designed to do nothing but protect tenants. They don't care an iota about the landlord.
Right. And I think that's what it comes down to for most of us landlords. This is not about landlords failing to recognize the dire situation that our country is in, or fail to be sympathetic or empathetic to what tenants may be going through. The problem that we have, and I think that most would agree, is that all of the bills give very little thought to the consideration of landlords and their ability to pay as well. Where is the assistance for landlords? Where is if we're going to be offering, for example, rent to be covered through the state or through state funding? I can tell you, as somebody who has one tenant who isn't paying, supposedly because of COVID, who filed for that rent assistance in late July, we've heard nothing and have received nothing. So, where is the help for landlords out there? And for those things that are being promised, where is the follow through on those promises? So that's, we're just in a pickle. We certainly, every single landlord that I've spoken to feels horrible for anybody going through a situation where they truly lost their job and they truly have a family to support. They don't want to kick people out on the street. That really is the case. On the other hand, at the end of the day, we don't want to be on the street either. And there's an obligation to pay the rent based on the contractual commitment. Now, beyond that, I did a video about 2 weeks ago on cash for keys. So I think it's worth mentioning one more time for those of you who have not watched my cash for keys video, and I'm guessing, Ken, you'd probably agree, if you can get out of this whole landmine situation and sidestep all of this to begin with and just simply give the tenant a couple $100 or whatever, pay them to move, you're probably better off.
Yes, I would agree. Rather than if the only thing you have to evict them on is non-payment of rent, you're in a real bind.
Yeah. Now, most of this is pertaining to non-payment of rent, right? If there is another blatant breach of lease, what does that look like in terms of giving them a notice to cure?
Well, right now, the court is interpreting the statute the same way I do, which I think is correct, that the CDC order only applies to non-payment of rent. However, I can tell you, I just had a trial yesterday where the tenant's attorney argued that non-renewal, because the lease had ended, is not covered under, or is covered under the CDC declaration because it doesn't specify that as one of the options. And they argued that that tenant, even though the lease had ended and that landlord had given proper notice that they weren't going to renew, that the tenant could stay under the CDC order and that the declaration protected them. And in that case, the judge ruled in our favor. And unfortunately, I fully expect that they will appeal. And if they file an appeal, we'll have to fight through the appellate process before we can get a writ, which is going to take 5, 6, 7 months. Well, by then the CDC order will have hopefully expired and it won't matter anymore anyway.
Right. Yeah. Before we finish up here, one last question for you. Can you just shed some light on the most recent updates from the governor's office here in Colorado pertaining to basically disclosure from landlords about the CDC order before we can initiate these evictions?
Yes, the governor just entered a new order on Tuesday that says that before you serve, or at the same time you serve, any demand for any reason, for non-payment, for non-renewal, for breach of the lease, I think it would apply to a substantial violation where the tenant is shooting at his neighbors. For any violation, you have to give the tenant a copy, and it has to be a complete and full copy of the CDC order and a full copy of the declaration. So now landlords are required to give that to the tenant. It has to be in writing. It does not say it has to be mailed or hand delivered. It just says in writing. So I think the way to do that is for property managers that all of you guys use portals, is to email it, because then you've got a written record, you have a date and time, and you can just email it to them and attach a PDF copy. For individual landlords that maybe don't deal with their tenants by email, you're either going to have to mail them a copy, or you're going to have to serve with the demand a full copy. And that is now required on commercial, residential. It doesn't matter what it's for. Polis's order said everybody.
And when does that expire?
Oh, it's like everything he does. It's 30 days from the date unless he extends it. So that one took effect September 22nd. So it'll expire October 22nd, but he extends everything over and over again. So I'm expecting it to extend.
So then you're kind of running into some other risks in that maybe you have somebody with 10 unauthorized dogs and you're evicting them because of these 10 unauthorized dogs. You're now telling them, hey, guess what? You have 10 unauthorized dogs, but hey, if you don't pay your rent, that's an option, right?
Well,
are you opening up a can of worms by even posting for any other reason?
Well, I don't think so. I mean, I don't think you've got any choice. Using your example, you still have to post them. You still have to take steps to go after them. But yes, by giving them the notice, you're just begging them not to pay the rent. And because everything you're giving them says if you don't pay the rent, there's nothing anybody can do about it. So that's the downside. But I don't know that you have any other choice. Yeah.
Okay. Well, this has been super helpful. I appreciate it. And we'll continue to do updates from time to time, certainly as these laws change on a state, local, federal level. And Ken, I appreciate your time.
Okay. All righty.
Okay.